Hello and welcome to the Minimum Competence episode for Monday, June 9th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Getty versus Stability AI in UK court, Damian Williams' law firm switch, and the NCAA's $2.8 billion player pay settlement getting final approval. Let's remember, civilizations die from suicide, not by murder, and read today's legal news. On this day in legal history, June 9th, 1954, one of the most pivotal moments in American legal and political history unfolded during the Army McCarthy hearings. The hearings were part of a broader investigation into allegations that Senator Joseph McCarthy and his staff had pressured the U.S. Army for preferential treatment of a former aide. By this time, McCarthy had become infamous for his aggressive campaign against alleged communists in government, using Senate hearings as a stage for accusations often lacking in evidence. His tactics had created a culture of fear and censorship across multiple sectors of American life. The dramatic turning point came when Army Chief Counsel Joseph Welch confronted McCarthy after the senator attempted to smear a young attorney from Welch's law firm. With millions watching the nationally televised hearing, Welch famously asked,
"Have you no sense of decency, sir? At long last, have you left no sense of decency?"
The moment drew applause and signaled a critical shift in public sentiment. It crystallized growing discomfort with McCarthy's bullying methods and marked the beginning of his political downfall. The legal significance of this day lies not in a court decision, but in the public rejection of demagoguery and the defense of due process and professional ethics. Welch's rebuke helped reassert norms of fairness in legislative proceedings and served as a precedent for reining in congressional overreach. Within months, McCarthy was censured by the Senate, and his influence waned. June 9th, 1954 thus stands as a symbolic restoration of institutional decency amid the legal theater of Cold War America. Getty Images has launched a major copyright lawsuit against Stability AI in the UK, accusing the company of using millions of its images without permission to train its AI system, Stable Diffusion. The case, now underway in London's High Court, challenges whether such data use falls within fair use or infringes intellectual property rights. Getty insists the lawsuit is not an attack on AI itself, but a defense of copyright protections, arguing that AI can thrive alongside creators if proper licensing is respected. Stability AI denies any wrongdoing, framing the dispute as a broader debate about innovation and freedom of expression. The legal battle is unfolding amid a global wave of lawsuits over AI training data as creative industries express concern about the unauthorized use of their work. Getty is also pursuing a parallel case in the United States. Lawyers for Stability AI argue the suit could endanger the entire generative AI industry, but Getty counters that respecting copyright is key to AI's future. The outcome of this case could reshape how copyright laws apply to AI in the UK and potentially influence government policy. One legal element of note is UK copyright's application to machine learning, particularly regarding the scraping of protected content. This is significant because the UK lacks a settled precedent on whether using copyrighted data to train AI systems constitutes infringement, especially in the absence of express licensing. The case could establish that precedent. Damian Williams, the former U.S. Attorney for the Southern District of New York, has left Paul Weiss just months after joining the firm to move to Jenner & Block. His departure comes as Paul Weiss faces scrutiny for striking a controversial deal with the Trump administration in March, agreeing to provide $40 million in pro bono legal services in exchange for rescinding an executive order targeting the firm. Jenner & Block, in contrast, opposed the same Trump-era executive order in court and recently secured a permanent ruling against it. Williams will now co-chair Jenner's litigation and investigations practice. During his time as U.S. Attorney, he led major prosecutions, including those of FTX founder Sam Bankman-Fried and Senator Bob Menendez. In a statement, Williams praised Jenner's fearless advocacy and strategic counsel. Jenner did not mention its legal fight against Trump or Paul Weiss's agreement in its announcement. Paul Weiss has seen several other high-profile departures in recent months, including 5 partners who left to start a new firm and the head of its pro bono practice who left to work on housing advocacy. The Trump-related agreement has sparked debate within the legal community, with some praising it as pragmatic and others criticizing it as compromising firm independence. A federal judge has given final approval to a groundbreaking $2.8 billion antitrust settlement between the NCAA, its Power 5 conferences, and student athletes, allowing for direct payments to college athletes for the first time. Judge Claudia Wilkin ruled that the deal, which also resolves ongoing litigation over name, image, and likeness or NIL rights, was fair and served pro-competitive purposes despite concerns raised over team roster limits and compensation caps. As part of the agreement, schools can begin sharing up to 22% of their athletic revenue, around $20 million annually per Power 5 school, with athletes as soon as this summer. The deal includes $2.75 billion in back payments over 10 years to Division I athletes who played from 2016 onward. Some athletes had objected, citing unfair pay practices, gender inequities, and a lack of input from future players. Wilkin responded by approving revisions that exempt some athletes from roster limits and clarified that future athletes can object to the settlement before being bound by it. Less than 0.1% of nearly 390,000 class members formally objected. While this decision marks a shift toward a new financial model in college sports, litigation will continue. Former athletes not covered by this deal are still pursuing claims, and broader legal fights remain over whether athletes should be considered employees. NCAA President Charlie Baker emphasized the deal as a stabilizing step amid ongoing legal and political challenges, including state-level competition over NIL rules. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the measure of a civilization is how it treats its weakest members.